Hello everybody, welcome back to the Butterfly Monkey Effect channel. Hopefully you guys enjoyed the last two videos. I apologize that chapter 1 is taking so long, but it will be done today. And then contracts I think will be next. I'm taking long because I'm writing other stuff among personal events that I have to attend. And my niece's birthdays and quinceañeras and all that stuff all this month. And it's actually going to be in October too, so we'll see how that goes. But to continue, right, so this is part D of chapter 1, right, specifically starting with section 71. And this goes to like 105, I think it is. I'm going to try to kill that today. So to continue, part D, procedure. 71, prosecutions versus lawsuits. The state punishes a criminal by apprehending him, bringing him to trial, and, if guilty, imposing sentence. The procedure is known as prosecution. A lawsuit, on the other hand, or civil suit, involves a private dispute wherein a person wronged by another seeks redress against the latter in the form of money damages, recovery of property, or some special form of equitable relief, such as injunction, specific performance, partition, foreclosure, accounting, rescission, or the enforcement of a trust. Criminal prosecution. A criminal prosecution is usually instituted either by a warrant for a person's arrest or by a sworn information on which a magistrate issues a summons or a writ directing the accused to appear before him. In minor cases, the magistrate tries the accused and either acquits him or imposes a penalty. In serious cases, he has jurisdiction only to commit the accused to prison, subject to bail, to await grand jury action. The grand jury usually consists of 23 men convened from time to time to investigate charges of crime laid before them. Proceedings before a grand jury are not in the nature of a trial, but are one-sided. That is, the district attorney, representing the state, merely presents the evidence. If the grand jury finds that the crime has been committed, it draws up a written accusation, finds an indictment on which the accused is tried. If, as sometimes happens, the evidence comes before the grand jury in the first instance, the criminal being at large, an indictment is found, and the authorities endeavor to arrest the criminal and bring him to trial on the indictment. On the trial, 3 things must be established. The corpus delicti, or body of the offense, that is, the commission of the crime itself. 2, the connection of the accused with the crime. And 3, guilty motive or intent, except where intent under the statute is not a necessary element of the crime. See section 32, which was above. As to intent, the law presumes that everyone contemplates the natural consequences of his act. This is a quote. This is no different than saying ignorance of the law is no excuse. As to intent, the law presumes that everyone contemplates the natural consequences of his act. In criminal cases, guilt must be established beyond a reasonable doubt. Lawsuits and judgments. The object of a lawsuit is to obtain a legal determination requiring a person to do or refrain from doing something. Summons, parties' jurisdiction. A lawsuit is started by the service of a writ or summons. The person suing causes the writ to be served on the person sued, the defendant. And this requires the latter to appear in court on or by a given date. This gives the court jurisdiction. Pleadings issue. I would have liked to know if. Well, I know the appearance does give court jurisdiction, but the actual suit itself, like the filing, like the process to file, meaning you file at the court and you give all parties notice. Does that give the? I think no, but the question is, does that give the court jurisdiction to the defendants on the defendants? And I say no because of some other things that I read, especially if they're non-resident, out of state or whatever, right? They for sure, right? It all depends on the type of crime too, I think, or a suit. Pleadings issues court calendar. The wrong to the plaintiff is set forth in a complaint known as a declaration in some states, to which the defendant must serve his answer. And this is no different when you're dealing with anyone else, like government or whatever. If they have an obligation to respond, like then you have acquiescence if they don't. And that's why your administrative process should be you sending them either whatever the notice is or a response 3 times. And if they don't reply after you follow the proper protocol, right, by statute for notices and whatever else, if they don't reply, then you could take them to court for an injunction. Well, for other things, injunction for sure. Like if they took your property and stuff like that, yeah. Like my buddy, like he got his car taken and he don't want to do nothing about it. He's on some syntax grammar, and the only thing he's telling him is that this is fraud language. That's it. Got his car taken, he ain't gonna get shit back. It's been a year. But his whole argument, fraud language. Instead of fighting and arguing against what they're accusing him of, meaning if they had the power in the first place to do what they did. That's how I look at it. Where I leave off. And also, if he sees fit, any cross-charge or counterclaim to the plaintiff's complaint, to which the plaintiff may reply. These charges, defenses, and cross-charges are known as the pleadings, which create the issue in the case. These issues are brought to trial by being put upon the court calendar. Well, there's a little bit before this, right? It's a back and forth between both parties until either all the disputes are either agreed upon or disagreed upon. And then it goes into trial. When everything's agreed upon, there's going to be no trial. If there's disagreements, then there's going to be a trial because a fact finder needs to adjudicate the issue. Trial. Upon the call of the calendar, the case is tried when reached. The attorneys for both sides select or impanel a jury, then open to the jury, that is, explain the nature of their respective contentions. The plaintiff's attorney puts on plaintiff's witnesses in any order he may select. He elicits their testimony in the first instance by direct examination, then must submit them to cross-examination by the defendant's attorney. The defendant's attorney then puts on defendant's witnesses, who likewise testify upon direct and cross-examination. The plaintiff need not establish his case in a criminal prosecution beyond a reasonable doubt, but by a preponderance of evidence, which is not measured by the number of witnesses, but by the quality of their testimony. The attorneys then sum up the evidence. The court charges instructs the jury on the law, and the jury retires to deliberate the facts. Judgment, execution, levy. If a jury finds for the defendant, the case is dismissed. If for the plaintiff, a judgment is entered for the amount found, and the judgment is carried out by issuing execution to a sheriff or marshal, who must make demand for payment, and if such demand is not met, seize or levy upon defendant's property and cause it to be sold to satisfy the judgment. Supplementary proceedings. If the sheriff or marshal, unable to find property belonging to the defendant, returns the execution unsatisfied. Plaintiff's attorneys may obtain a court order or, in some states, may issue his own subpoena for the examination in supplementary proceedings of the defendant, now known as judgment debtor, to ascertain, if possible, the existence of any property or income which might make the judgment collectible. So this is a search for everything, all his other property. That's what this is. Supplementary proceedings is a search for that defendant's other property. Garnishment. If the judgment debtor has no money or property in his possession, but money or property is due him from a third party, the judgment creditor, successful plaintiff, must institute garnishment proceedings to satisfy his judgment. Now, here in trust law, right? This right here, money or property is due to him from a third party. The only way that a creditor or whatever is trying to collect from you, from the beneficiary, let's say the beneficiary, is if the beneficiary has power over that distribution. Meaning he could determine or dictate when he gets it, or something to that extent. The court finds that he has direct control over that money. So the court could command him to start paying. But if he doesn't have control and the trustee has all control, then they could tell him, the beneficiary, anything that they want. But if he has no control, he can't pay that money that is due to him. It's different when he collects. But I'm saying due, because the contract in the trust says what? That distributions, maybe, on the sole discretion of the trustee, whatever. Okay, well, if the trustee chooses not to give it to him, then the trustee chose not to give it to him. And there's no court that could say and demand the trustee to give it to him, because the beneficiary himself don't have power. The judgment creditor, successful plaintiff, must institute garnishment proceedings to satisfy the judgment. The third party who owes the debt to the judgment debtor and against whom such proceedings are brought is called the garnishee. So this is what they do to your employer, to your job. The question is are they authorized to do that? Like, by what law or by what authority did you give them, or do they have to do that for your employer to garnish you? They got another section, 1365, coming up for that. I kind of want to look at it right now. I probably will. Where the garnishee is an employer owing wages to the judgment debtor, the proceedings are sometimes referred to as execution against income. The employer need not withhold the entire wage, but only a percentage, usually 10%, fixed by statute. Any excess over such percentage, which the employer may have withheld, belongs to the employee. The same section. Statutes generally prescribe a fixed minimum wage which is not subject to garnishment, which, $8 or some crap. So 1365, let's go there though. Let's see what they're talking about here. I thought about doing these questions too at the end of the chapter, but like if I don't know the answer, like verbatim or something, because for me, you would want to do what the book is telling you, the answer that the book gives you. I can't find it in a good amount of time that wouldn't make this video extensively long. So it's like these are questions that people should look up on their own because it helps with their research. 1365, right? Oh, looks like a court case. So right here. So 1365, this is, I'm guessing New York, October 1943. I don't know what the 15 stands for. A, define 1, garnishment. 2, garnishee. B, an envelope is an employer's cash drawer containing a week's wages of an employee is marked garnished. Number 1, to whom does the money belong? Right, which is really the question, right? Why could your employer do this to you? Could do this to you? What action does the employer take on this? Now that's the crazy part. Is like because of trust law, right? When the beneficiary has no control, there's no doubt that he doesn't own that money. He has a right to it, but he can't demand it, right? When he receives it, that's different. It's all his, right? So it's like, well, but here the thing is specifically in the trust contract, right? The beneficiary is told he has no power over it. What's the difference between that and your employer contract, your employee contract or master servant contract, right? What's the difference between them? Where is it in that contract that says that before you receive that money, a third party could come collect and garnish some of it? Which, of course, is probably in some statute dealing with employee. When you fall under the category of employee, right? Well, they said, what they call it above, income garnishment or income something. So I'm going to have to say it's probably based on income, based on garnishment from income, on income tax, under income taxes. A1, garnishment is a proceeding to satisfy a judgment out of the monies or property in the hands of a third party due and owing to a person against whom the judgment is procured. It consists of obtaining a court order and serving a copy of it upon a third party. For example, an employer who owes money to the judgment debtor, meaning the defendant, right? The execution amounts to a command by the court and an authorization to pay. Upon presentation, the execution constitutes a lien and continuing levy, Section 73. So that was coming up too. Upon all subsequent earnings of the judgment debtor until the debt is paid. I guess the key thing here is a lien. Why are they able to put a lien on your labor? Because it's money or property that you haven't received yet. Because I know the law states that it's not until you receive it, whether that's in your bank account or something. All it means is that it gets released from the hands of the employer, the person who's paying. So it's like constitutes a lien on what? Where's the context of the authority to do this? I understand the execution that the court is ordering it, but the order is specifically on this property. But the execution constitutes a lien and continuing levy. The word garnishee is borrowed from the French language and is derived from garnishment, or from the word garnir, meaning to warn or give notice. Garnishment is correctly defined to be a proceeding in the nature of an attachment or execution, by means of which credits, property, or effects of the debtor in the hands of a third person may be subjected to the payment of the claims of the creditors of such debtor. And that's the thing. This is what you would want to study. For sure, attachments, executions, and liens, dealing specifically with garnishments. Understand how do you get out of this attachment? How do you get out of this execution? Right? Since that's what they're using, a court order to put levy on something you haven't received yet. When they do it to your bank, I want to say that's different, because that's your bank. It's in, you're supposed to be in your, I want to say, what would it be better? In your possession or in your control? No, it can't be control, because if you have a debtor creditor relationship or account with a bank, they have control for sure. You have a right to possess it, to use it, right? But they have control. What's the citation? They give you a court case right here. Collar versus Sheffield Farms. Number 2, the garnishee is the custodian of the property or funds in his hands attached. He is not interested in the result. He simply follows the orders of the court, and they give you. I guess I would read that case just to find out about that. Like, it's the whole thing, the order of the court, that I want to learn about. And it's the same case out of New York. B, number 1, the monies belong to the employee, subject to the lien and levy of the execution, and subject to the order of the court, that a stated percentage be paid over to the sheriff, marshal, or constable toward satisfaction of the debt. The employer must pay over to the sheriff, marshal, or constable who served the execution the amount therein specified until the execution is wholly satisfied. See, I haven't read nothing on garnishment, so like right here, this sounds fucked up because of the principles of trust law. I guess it's because the law doesn't show or state the statutes that I don't know. I don't want to make a judgment on that or some theory on it without reading more on garnish. But it's a little interesting little thing right there. Let's see where I was at. Not here. I was like on 73 or something. Right here, garnishment. So the next one is attachment. In exceptional situations, as for example, where the defendant is a non-resident or threatens to leave the jurisdiction, an action may be begun by a writ of attachment commanding the sheriff to seize the defendant's property as security for the satisfaction of such judgment as the plaintiff may recover. I think the key thing is, or it says the defendant non-resident or threatens. Can't stop from leaving. But if his intent is to skate out of a debt, right, that's different. When he's threatening to leave the jurisdiction, that's different. I thought there's a section here for liens. I thought one of these sections coming up was liens. I don't know. 74, courts. A court consists of a judge and jury. The judge expounds the law. The jury finds the facts. Equity or chancery cases are usually tried by a judge without a jury. And where the facts are involved, detailed or complicated, as they frequently are in patent and other litigation, the court may refer the case for fact-finding purposes to a master in chancery or referee. They they call them something else too. Master something though. They're not master in chancery. It's master in something. The last place where I heard of that is during Trump's court cases. They used it. So there was a lawyer that I was listening to, and he was saying, well, Judge Napolitano, right? He was saying that Trump's team fucked up because they didn't call upon the master prior to some other process. and that allowed something into evidence or some crap. I forgot. It was a couple years ago already, but there's another term. A court has no power over a party unless it obtains jurisdiction or authority to render a binding decision. The jurisdiction of the various courts depends on various factors: residence of the parties, amount in suit, nature of case, location of property in real property cases, and so on. Jurisdiction may be original for trial in the first instance or appellate for review of the lower court. Evidence of object of. All testimony given upon a trial must conform to certain rules of evidence, the object of which is to establish the truth or falsity of a given charge or assertion. Judicial notice. Certain matters of common knowledge need not be proved. The court will take judicial notice of them. And this is also too. Say you know something. You're stating a stipulation that's a fact. But you don't need to go further into it because it is a well-established fact. But you, in your pleadings, you have to say that you want the court to take judicial notice. You want to stipulate it, that they take judicial notice of it. This right here, this is a lot of problem. This is right here is a lot of issues that people have. People believe that they could write up their own stuff. For everything. I'm not saying you can't, but for everything, right? Not understanding or caring, right? You're going into their house for court. Why would you give them paperwork that would literally be jibber jabber to them? Why wouldn't you follow the procedures that they are established? As long as those procedures are not unconstitutional, right? Then follow the procedures so they can't kick you out for some technicality. People don't want to do this. Conform to certain rules of evidence or whatever else. For procedures, for process, notice, complaints, suits. You gotta... I don't know. Burden of proof. The burden of proof is on the party holding the affirmation, usually the plaintiff. That is, he must go forward with enough proof so that if nothing were shown to the contrary, he would win. This puts the burden on the defendant. If the defendant fails to meet the burden with equal proof to the contrary, the plaintiff is entitled to judgment. If the defendant meets the burden and the plaintiff fails to present additional proof to outweigh the defendants in the case, his counterclaim or counter-argument, the case is dismissed. Classifications of evidence. There are numerous classes of evidence, including, among others, the following. Prima facie evidence. Like, here's one, right? You'll hear people say statutes are not law. Okay. Correctly stated, they're not law in terms of the Constitution. What they are prima facie evidence that a law exists. Right? So you to follow the line, right? It's the Constitution, then the statutes at large. The statute at large is presumed to be in full compliance with the law. But nonetheless, it's prima facie evidence that it's in compliance with the law, with the Constitution. And it goes further. You break it down. The code has to be in compliance with the statute, and the regulations have to be in compliance with the code. So it's not to say that it's not a law. It's just being used incorrectly, the term. It's evidence. It's potential evidence that a law exists. That's how you have to look at it. And it's up to you to find out, to make sure that there is a law that backs that statute up, that code up, or whatever. Or, for lack of a better word, that law, that people say that statutes are not law, which is true. They're prima facie evidence of a law. Prima facie, conclusive, direct, indirect, or circumstantial, real, relevant, material, competent, primary, or best, secondary, and hearsay. So all the different classifications, but we already know circumstantial, it might be a form of evidence, but you're trying to force something in, hearsay for sure almost don't work. Prima facie evidence. Prima facie evidence is evidence which, standing alone, unexplained, and uncontradicted, establishes the proposition or conclusion to support which it is introduced. For example, prima facie evidence of a debt is evidence which, if not controverted by evidence to the contrary, establishes the existence of a debt. Prima facie evidence of a debt is evidence which, if not controverted by, they don't give the specifics. Like what's the evidence of debt? Is it a promissory note? Even if it's a copy? You know what I'm saying? By evidence to the contrary, establishes the existence of a debt. And more than anything, like, if not controverted, dude, that's acquiescence. They came at you with something that looks real, but might not be real. You didn't say nothing against it, so now it is established that it is real. Conclusive evidence. Conclusive evidence is evidence which is incontrovertible. A, as a matter of law, such as the presumption of ownership from adverse use. See section 1041. Or B, as a matter of fact, such as evidence from which only the reasonable conclusion can be drawn. Direct evidence. Evidence consists of testimony by persons who saw, heard, or sensed the matter in controversy, so that they can testify on direct knowledge. If, for example, it is desired to ascertain whether the accused has lost his right hand and wears an iron hook in place of it, one source of belief on the subject would be the testimony of the witness who had seen the arm, or got his arm chopped off, or got the hook put into place or something, instead of making that person take off the hook right then and there. Right? If you're trying to prove that he got his arm cut off and he has a hook, then right in front of you, he could just pull it off and there you go, right? But here it's testimony. The testimony states that he was present for whatever reason. They give an annotation. And Wigmore on evidence. That's a law book. An authority on law. Authority on the law of evidence, I guess. Indirect or circumstantial evidence. Indirect or circumstantial evidence is evidence which tends to establish a fact, not by direct proof of its existence, but by indirect proof from which a logical inference may be drawn. To where Wigmore's illustration again, the mark of the hook on something carried by the accused would furnish circumstantial evidence that the accused wore a hook in place of a hand. Real evidence. Real evidence is that derived from personal observation by the court and jury. Again, using Wigmore's illustration, if the jury inspected the accused arm and saw the hook, this would constitute real evidence. Relevant and material evidence. Relevant and material evidence are closely akin, similar, or the same. Evidence is relevant when it touches the issues and assists in determining their truth. Material when it is not. Evidence is relevant when it touches the issues and assists in determining their truth. Material when it is not only relevant, but also has a direct bearing on the decision. So evidence is relevant when it touches the issues and assists. Okay, and material when it's not only relevant, meaning it assists in determining the truth, but also has a direct bearing on the decision. The practical conditions under these cases are tried do not always permit the court to hear all the facts which may be in any degree logically relevant to the issue, but requires that the facts received shall have a somewhat higher degree or probative force, which may be termed legal relevancy or materiality. The rule of this connection is that whenever the court feels that a fact is not of probative value commensurate with the time required for its use as evidence, either because too remote in time or too uncertain or too conjectural in its nature, the fact may be the exercise of a sound discretion be rejected. I don't like that, how they're saying the rule, right? What is it? What does it say? Where the judge, whenever the court feels, just a stupid way of phrasing this right here. Whenever the court feels. Competent evidence. By competent evidence, says Greenleaf, and I guess he has a book called Evidence, 16th edition. I'm going to look. You guys should go on Google Books and look up these books. Just type in the word Wigmore for the person, or Greenleaf, or just the word evidence. Treatise on evidence, all that. Like, you'll find something. Says is meant that which the very nature of the thing to be proved requires as the fit and appropriate proof in the particular case, such as the production of a writing where its contexts are subject to inquiry. If proof is incompetent, it is inadmissible, however relevant it may be. Thus, in a breach of contract action, testimony on the context of the written contract may be relevant. Yet, if the contract itself is available, the testimony will be incompetent and hence inadmissible, because the contract itself will be the proper evidence. And that's what's true. Like, people always want to say like form over substance and shit like that. Like, man, but it's not true. It's always going to be the substance. Like the actual contract, the powers that you are given and stuff like that over what you think that you're supposed to be doing. The law is the contract. So they see your actions, what you're being accused of. The contract says this. If you're not doing this, and of course that's the interpretation of the court based on the principles of law that they adopted, like from common law or equity, right? That the interpretation of the court based on that against what it is that you think that you could prove or not prove or whatever. Where did I leave off at? Competent testimony is distinguished from competent evidence in that it relates to the witness rather than to the evidence. Incompetent witnesses may include insane persons, infants of tender age, and persons in a complete state of intoxication. Witnesses interested in the event, a plaintiff or defendant, for example, are deemed biased but not necessarily incompetent, except as against the estate or survivors of a deceased person, in which case, since death has silenced the one, the law will silence the other. That's a crazy thing right here. Witnesses interested in the event are deemed biased, but not necessarily incompetent, except against the estate or survivors of a deceased person. Privileged communications. Because of their particularly confidential relationships, certain parties are made incompetent by law to testify as to privileged communications between them. And I'm not going to read them all, right? But you have attorney and client, right? Physician and patient, your preacher, clergyman and penitent, and husband and wife. No, I don't want to read them. An attorney or counselor at law is not allowed to disclose a communication made but to him by his client or his advice to the client thereon. This includes any clerk, stenographer, or other person employed by the attorney, such as an interpreter. The client, however, may waive this privilege, and if he does, the attorney may be compelled to testify. Well, you got to remember, he's your agent, too. Physicians are forbidden to disclose information required in a professional capacity unless the patient waives the privilege. Confessions and admissions made by the clergyman or priest in his professional capacity are privileged. Some states refuse to recognize this privilege. I think New York's one of them. Husband and wife. At common law, the husband or wife of a party to an action was wholly incompetent to testify as a witness. Statutes have largely qualified this rule. Husband and wife may now generally testify for or against each other, except as to confidential matters between them. And that's, where did I read that at? Like they threw out a testimony from a wife because even though she has the right to testify against him, the conversation was a private matter. It wasn't meant for no one else. Like the husband was able to prove it, and they threw the case out, and that's how the guy ended up beating him. Testify against each other, confidential matters between them. Neither may testify against the other in divorce actions except to prove the marriage or to disprove accusations or defenses or accusations. Communications not privilege. The mere fact that a communication is imparted in confidence does not make it privilege. Hence, confidential information imparted to or acquired by bookkeepers, detectives, merchants, bankers, agents, co-partners, or business employees generally cannot be refused on the witness stand. Though to disclose it voluntary might constitute a breach of contract or breach of faith. See, like they're telling me they can't refuse it. But what are all these things? Well, I don't know about bookkeeper, but these things right here, I would look at as corporate. Because no doubt, if you guys read Hale versus Henkel, they'll tell you specifically the line between a corporate officer or an employee versus an individual. Or if and when who is forced to give up information and not be able to use plead the fifth. Hale versus Henkel. I highly recommend you guys read that. 1910, I think. No pledge or of privacy nor of secrecy can avail against the demand for truth in a court of justice. So, pinky swear, it don't work. I promise not to tell them, right? I would like to read more up on this, though. Because there is like a thing, there's a catch on why you can't use the fifth on everything. And I guarantee a lot of it has to do with some type of corporate or public structure, maybe activity. I don't know about activity, but something dealing with the public for sure. Just like how they describe it in Hale versus Henkel. Because they break down in that case, like if and when you're compelled to give up certain information. Like when does it not constitute a violation of the Fifth Amendment or whatever? Newspaper editors and reporters. The rule of privileged communications does not apply to communications of a newspaper editor or reporter, for although there is a canon of journalistic ethics forbidding the disclosure of a newspaper source of information, it is subject to qualification and must yield when in conflict with the interest of justice. And now you know why some journalists go to jail for contempt of court and stuff. Accordingly, a witness before a grand jury on the complaint for libel published in a newspaper may be required to disclose the name of the writer, which he admits he knows, over the objection that it is an office regulation that the editors of the paper are not to give the name of the writer of articles published in it. Now here, key word here, office regulation. What's another one? Company policy, meaning it's not law. So like, for another example, when they're asking you for a social security number for like a bank account or an employment, the question is, what authority do they have to ask you for this information? And then 2, are you required to give up the number? And under what circumstances or context do you actually have to give up the number? So they're telling you office policy, corporate policy, all that shit. That don't mean nothing. Especially with the social security number, when that number is only meant for you to communicate between government. If a private business wants that number, and you're not using it for any government benefit or privilege, or submitting it to him for any government benefit or privilege, like withholding, with taxes and stuff for either income tax, social security, or whatever else, right? Then, like, they have no right to it. They have no right to the number. That's something that needs to be pounded into your head. Private business do not have a right to your social security number unless that private business has some deal with the federal government to give you some type of benefit, and then you're subscribing for that benefit. You're asking them to withhold for you, like a W-4 form. And then, right, when you give them a W-4 form, right then and there, you just gave them the obligation, your employer, to report on your behalf. Which the whole statute says that they only have the right to request a number from you if they have the obligation to report on your behalf. You're the only person who could give them that power to report on you. Fucked up, man. Hey. Accountants. Under the common law, that is, in the absence of statute, there is no privilege with regard to communications made to an accountant. The information given to the witness and to the accountant in his employ for the purpose of making financial statements and doing other work characteristically performed by accountants is not privileged, despite the fact that the witness may also have rendered legal advice on the basis of such data. However, in some states, communications to accountants in their confidential capacity have been made privileged by statute. In Illinois, the statute provides a public accountant shall not be required by any court to divulge information in which has been obtained by him in his confidential capacity as a public accountant. Other states, what is that, number 23? Illinois revised statutes. I wouldn't even know where to find this. Aside searching this, but what is it now? What is it today? What's the stat? Where is it located at today? I haven't studied this, so I wouldn't know. Other states which have adopted similar statutes are Colorado, Florida, Iowa, Maryland. And here's the thing too: is like it has to be only by statute that they give the privilege, right, to not divulge that information because of the nature of what a public accountant is. I swear, it's all revolves around corporate capacity. If they're telling you that you cannot withhold this information, that's because the thing that you're doing or the person that you're acting in, right, is a corporate construct in some way. Primary or best evidence. Primary evidence is the best evidence of which a case in its nature is susceptible. If a witness is personally liable for testimony, his own direct testimony on a pertinent fact is the best evidence. A writing itself is the primary or best evidence of its contents. The best evidence rule. Testimony on the contents of a document is inadmissible if the document is available, because the document in itself is the best evidence, which is absolutely true. Even this is even over a grantor. Like, you can have your grantor speaking, testifying, but if you have the trust indenture, right, the trust indenture beats out the grantor. The only thing that they would need the grantor for is to ask him questions pertaining to his intent. But the document itself is what governs. A party sues for trespassing and cutting down his trees. If he is asked on direct examinations, do you own the farm? The question is objectionable because the deed to the farm is the best evidence. Whenever it becomes necessary to prove the contents of a document, it must be produced or its absence accounted for. What's this one here? In 1938, the Committee of the American Bar Association on Improvements in the Law of Evidence. See, I would search this word on Google Books. Law of Evidence. Recommended that the legislators refuse to create any new privileges for secrecy of communications in any occupation. That the legislators recommended. So they recommended that the legislators refuse to create any new privileges for secrecy in communications in any occupation. And particularly, we recommend against any further recognition of A, privilege for information obtained by accountants, like Illinois, and B, privilege for information obtained by social workers. C, privilege for information obtained by journalists. They want them all talking. And how much more I got? A little bit more, ain't much more. Secondary evidence. If a witness is not personally available for a testimony, as where he resides outside the jurisdiction or is dead, secondary evidence may be used, as in the case of non-residents, depositions properly taken, or in the case of deceased person, testimony by another not interested in the event. So that person who's testifying can't have like a benefit, can't benefit in any way. Like if the guy, your father died and the inheritance is going, there's 3 kids, all the inheritance is going to go to his oldest kid. Well, you can't have the oldest kid testify for nothing because he's biased. Can't have an interest in it. I would think you can't have the other kids testify either, but I don't know. Because they don't have an interest but are trying to get an interest. I don't know. On what such deceased person had said that is competent and material to the issue. What's crazy is my old man, he had a mild heart attack. No, sorry. Yeah, well, he did a few years ago, right? Like 6 years ago. But when my uncle passed and we're all in the hospital, right, while he was in a coma and stuff, my father let it know to everybody here. And he, of course, he scolded me first, right? And he doesn't want to live like this as a vegetable. He doesn't want to be in a coma and all that shit. He's telling us, right then and there, he's telling us all. So we're witnesses that he pulled the plug. Don't let me sit here and suffer like this and hope. And my thing is like, damn, you don't even want to wait like a week, 2 weeks, a month. You know what I'm saying? Like, just to pull the plug right away, I hate that. I don't like that. And I would argue that too, right? I would at least argue it, damn, wait a month or something like that. You know, of course, chance and God could all step in and, but the thing is, it's his choice. In the end, regardless of what I want, right? It's his choice. Right? I don't want to see him like that either. But I want all facts. I want everything. I want this doctor to tell me every single fucking thing that can happen or won't happen or the 1% chance of happening, all that shit. So I could do some research or do something, second opinion, something. Exhaust it. Hearsay evidence is evidence on a fact-based, not on the witness's own knowledge or observation of the fact, but on what someone else told him about it. Such evidence is objectionable because it cannot be tested by oath or cross-examination. The witness cannot swear or respond on cross-examination as to the truth of the alleged fact, but only as to the truth of someone having told him about it. For example, in a suit for trespass previously referred, if the question were asked, did you see the defendant chop down the trees? The answer, no, but my wife saw it and told me about it. Would have to be stricken out as hearsay. Exceptions to hearsay evidence rule. There are numerous exceptions to the hearsay evidence rule, such as confessions, admissions against interest, like a dying person, right? Like, oh, Jack killed me. And he told that to the paramedic, and the paramedic is the only one there. Like, and of course, that's the dying declaration right here. Declarations of a testator, and so forth. And this declaration of a testator is like, the reason why this is important too, right, is because say you never specifically created a will, okay? But you took measures and did actions or activities that combined all together is evidence that you did create a will. Like when you put the whole book together, it's a will. So all those actions comprise as creating that entity, creating that contract. Section 1167 and so forth. Exceptions of interest to students of business law include book entries, statistical tables, charts and analysis, and expert testimony. The expert testimony, that's not really hearsay. That's his opinion or his testimony from years of sampling similar situations and stuff. Like these right here, book entries, one thing that's it comes from the person or something like that who took on like your secretary, right? Book entries. The shop book rule. Declarations in the form of book entries are hearsay, but when made in the regular course of business, like your secretary, they carry some presumption that they reflect the facts on record. Such a presumption is, of course, prima facie only, subject to rebuttal, and that's true. It's the same thing. It's like your secretary, right? She's just taking notes. You're taking her word that she copied down everything you said verbatim. And it's going to be prima facie until what? She has other people, the secretary has either the person who stated it and maybe another witness that was in the room, all stating, yeah, those are the exact same words. Well, that right there, no more is a presumption, no more. It's not prima facie or anything. This rule of evidence is known as the shop book rule. It is hedged about by a variety of conditions, some of which have been retained in some states, dropped in others. For example, books of accounts were originally admissible in New York only on the following conditions. The party kept no clerk. B. Some of the articles charged had been delivered. C. The books produced were the regular account books of the party. And D. The party could show by those who had dealt with him that he kept fair and honest accounts. These conditions have been dropped from the New York statute, which now provides any writing or record, whether in the form of an entry in a book or otherwise, made as a memorandum or record of any act, transaction, occurrence, or event, shall be admissible in evidence in proof of said act, transaction, occurrence, or event. If the trial judge shall find that it was made in the regular course of any business, and that it was the regular course of such business to make such memorandum or record at the time of such act, transaction, occurrence, or event, or within a reasonable time thereafter, all other circumstances, it says all other circumstances of the making of such writing or record, including lack of personal knowledge by the entrant or maker, right, the secretary, may be shown to affect its weight, but they shall not affect its admissibility. So they could attack the maker, the writer of the book. Bias, all that, whatever it is that you got that person could have been biased in one way or another writing it, among other things, probably. The term business shall include business, profession, occupation, and calling of every kind. I would want to read that. And that's under Civil Practice Act. So it's an act. Especially when they're saying in the course of business. Like, what I'm saying? Like, everyone has bookkeepers. That's, I don't know. Statistical tables. Standard statistical tables commonly accepted by authentic may be admissible as proof of the facts therein tabulated. Examples of mortality tables, stock exchange quotations, census tables, and so on. They give an annotation. In a recent case, the author introduced in evidence a statistical compilation showing relative popularity ratings of different types of radio programs, taking from a standard statistical publication commonly used in radio advertising. Charts and analysis. As an aid to the court, statistical charts and analyses of properly established facts are frequently admitted into evidence, provided a proper foundation is laid for their admissibility, showing how they were prepared, who prepared and checked them, and so on. Opinion evidence, expert testimony. Ordinarily, a witness may testify on facts only. His opinions are inadmissible. However, an important exception is furnished in the case of experts who may either A, testify to specialized facts only and let the jury draw its own conclusions, or B, testify specialized facts and give their expert conclusions as well. The latter category includes testimony by doctors, lawyers, certified public accountants, scientists, engineers, merchants with knowledge of values, fingerprint, and handwriting experts, and all persons generally who possess specialized knowledge of the subject under inquiry. Qualifying the expert. The attorney who puts an expert on the stand must first qualify him. That is, ask questions, the answers of which will show that the witness is qualified to testify as an expert. A medical expert, for example, will be examined on his education, training, and experience. An accountant will show that he has been duly certified by the official examining board. Hypothetical questions. Experts are not called to testify upon particular facts of the particular facts of a case, but upon their opinion on an assumed state. Put this away. On an assumed state of facts, which must have some relevance to the facts under inquiry. Such testimony is elicited by putting a hypothetical question to the witness reflecting the facts which counsel assumes to have been proved on the trial, and then asking the expert his opinion on such an assumed state of facts. Bars of recovery. In general, one may be wrong. So this is part E. Bars of recovery. In general, one may be wrong yet have no legal remedy if he waits too long to seek redress, or if his suit is inconsistent with prior conduct. In the former case, a remedy may be barred by the statute of limitations or by laches. In the latter, by estoppel. Statute of limitations, definition, and object. The statute of limitations is really a collection of statutory provisions fixing a limited period of time within which to sue. Upon the expiration of such period, a cause of action is said to be outlawed. And they give us section 1376. The object of statutes of limitation is to expedite the prosecution of legitimate causes of action and to discourage the bringing of stale claims, like they did against, the guy who they keep trying to kill. What's that case? The sexual harassment case was so old, it getting dust on it and everything, that they put so many things together just to try to find him guilty on that. And I already read the stuff in the appeal courts. He's gonna win everything. Like he has won and shot down everything that they have thrown at him. You're talking about from 2 impeachment trial hearings, right? The only one that so far he has lost, and the $300 million in the suit, right, to the lady, he's gonna win all of those things. He already slammed them in Georgia. He's slamming them in Florida, in DC. Like, it's sick. If you read the court cases at all, right, forget what just following, not the news, but even independent journalism, right? Just read the thing yourself. You're gonna see how hard they're trying without the evidence, testimony, and all the proper stuff that we're reading here, right? To be able to find him guilty. Like, it's complete garbage. Like, bad. Where I leave. The theory underlining such statutes is that it is the general experience of mankind that claims which are valid are not usually allowed to remain neglected, and that a lapse of years without any attempt to enforce a demand creates a presumption against its original validity, and that it has ceased to exist. Furthermore, the neglect of a plaintiff is advanced as an additional ground for barring him from enforcing his remedy. The basic principle on which such statutes are most generally justified is that they tend to prevent fraudulent and stale claims from springing up at great distances of time and surprising parties or their representatives when all the proper vouchers or evidences which might be introduced in defense of the claim, or the facts which might bear upon the claim, become obscure. Under such circumstances, such factors as lapse of time, defect of memory, death, or removal of witnesses might constitute serious impediments to judgments. Yeah, but that's not true because they don't do that with all court cases and stuff, all charges. Murder for sure, that's forever. Like, it doesn't matter. Regardless of all these potential negatives, right, that they just stated, right, it doesn't matter. They'll still try to charge the murderer. So it's like, why even have statute of limitations, period, if your whole goal is to keep evidence? But then again, it's murder is murdering. So they give a chart here, which I did not see. No reference to it in what I just read. So a summary of commercial law, statutes of limitations, and number of years. So whatever these headings, right? Open accounts, promissory notes, oral, written, and under seal. I think I can understand this. But, I guess they're all contracts. Open accounts is what I won't understand. But these are all the years that they give specifically for these. Ordinary contracts or under seal contracts. Promissory notes and so forth. Illinois 510, 510, 10. They give you, I don't see no letter. Oh, well, there's letters here. Supported by book entries, negotiable and unsealed, 6 years. All others, 17 years. So where's a B? Right here, like B for Connecticut. Promissory notes have a 6 to 17 year statute of limitations. But then they give you something here. Negotiable and unsealed is 6 years. All others, 17. On contract, sealed or unsealed for payment of money, 10 years. On contracts to convey land, 15 years. On contracts sealed or unsealed, other than for payment of money, or to convey land, 20 years. Statute of limitations, period. The period of the statute of limitations varies with the type of action and the state having jurisdiction. It would be impracticable to list here the numerous variations in the different states or the different types of actions involving different periods in the different states. A tabulation showing the statutory periods in the different states for the most common types of commercial transactions is shown on pages 4. Well, that's what the chart. Variations as to types of action in a single state, New York, are shown in the table on page 46 and 47. So this is New York's. This is everybody else. It's variations as to types of actions in a single state. Claims by or against decedent estates. A cause of action. Hold on, let me look. Let's go over this first before, because they reference me to look at it here. I ain't going to read it all because it's all New York stuff, right? So maximum periods for commencing suit in New York. 40 years. Action by state or by grantee from state affecting real property. 20 years. Action on judgment of court of record. For example, action in New York on judgment procured in an Illinois court of record. Action on judgment of court not of record but docketed in county clerk's office. For example, action on judgment in justice of peace courts of justice of the peace court, which has been docketed in the county clerk's office. Action in dower within 20 years from death of husband. I ain't gonna read them all, but that's 3 years, 2 years. Action against the sheriff or coroner upon liability incurred by him on doing an act in his official capacity or by the omission of an official duty, except non-payment of money, collection, exercise. Claims by or against decedent estates. A cause of action in favor of or against a person which is barred by the statute of limitations at the time of death is not revived by the fact of death. Some states have adopted statutes which provide, in effect, that the time which elapses between death and the granting of letters, during which interval the state cannot be sued or be sued, must be added to the statutory period. Other states provide a specific time after the death which must be added to the statutory period. In New York, for example, the statute provides that if a person who has a cause of action dies before the statute of limitation expires, and the action is not of a type which dies with the person, the estate may bring suit within 1 year after the person's death, though the statutory period has expired in the meantime. The statute also allows additional time to sue where a prospective defendant dies. However, executors and administrators, Section 1181, need not hold up the administration of an estate until all possible statutory periods shall have elapsed. Need not hold up the administration of an estate until all possible statutory periods have. So they're saying you don't have to. The law usually fixes a specified period, which may be shortened by advertising, within which creditors must present their claims if they wish to charge an executor or administrator with the assets of the estate. In New York, for example, the statute provides that if creditors do not present claims within 6 months publication period, or if no notice is be published within 7 months from the date letters were issued, the executor or administrator shall not be chargeable for any assets or monies that he may have paid in satisfaction of any lawful claims, or of any legacies, or in making distribution to the next of kin before such claim was presented. I think right here, how they said advertising, right, which may be cut short by advertising. This is public. I'm guessing advertising, they're referencing public notice for other people to bring charges against the state. Because, like, you guys understand that at least one portion of, like, a funeral procession, right, or marking the death of someone in a newspaper, like the obituary page, that is public notice for people who might have a claim on those estates. I don't want to say the whole aspect of like a funeral procession and the obituaries part, right? But no doubt that part plays a part in it, because you're making a loud noise in the public to get the attention of others that this great person has passed away. It's used as that, at least for sure. It might not be the whole aspect of it, but it's used as that. The filing of a claim with an executor or administrator has the same effect as the commencement of a suit. The statute stops running forthwith. Federal statutes tax delinquencies. In addition to the state statutes of limitations, various statutory periods are provided by federal law. For example, the statute of limitations on federal income tax assessments or for a proceeding in court without an assessment is 3 years from the date when the return was filed. The statutory period for a proceeding in court or for a distraint seizure of, which is a seizure of personal property, after an assessment has been made, is 6 years additional. In case of a false or fraudulent return or no return at all, the statutory period is suspended, does not run. A lot of people are going to find out about this, though. All the paperwork that people have been finding out with that, W-4 process and all these 1099s and all that shit, like, you're going to find out in them 3-year period. Or the 3 years when you first started writing them, or 3 years after you did whatever filing you did with them. I don't know, man. I've studied a good portion of some of those methods, and I'm a big person. I'm a person who flat out cannot stand people using definitions that have no applicability to the subject you're studying. And that's what I have found in some of those processes. They're forcing their theory on why this should work by introducing words and definitions that don't apply. I don't know how else to put that. They're forcing that. You can't do that. I don't want to say that's commingling, right? But that's something. You're doing something that you're not supposed to. That's not what a researcher does. For sure. Unless it incorporates it. That's different. Like when people tell me that when I tell people that the term the United States in the citizenship clause of the 14th Amendment, so I'm being specific here. The citizenship clause of the 14th Amendment, the term United States, does not include the territories, is not to be construed as a corporation, and it is defined by multiple court cases as the several states of the Union. So it literally stands for the United States of America. But people, even though I'm telling them the context of citizenship, will tell me, well, Title 28 says this, that the United States is a corporation. Man, Title 28 fucking has nothing to do with the citizenship clause of the 14th Amendment. One is the Constitution, which is law. The other one is statutory. One is dealing with the judiciary, and the other one is dealing with a fundamental law of citizenship. Like, you can't do that. Like, period. That people do anyway. And then criticize me for saying something about it. You're dumb. You're doing yourself a disservice by not properly breaking down every single word that you read and just trying to make it fit what your opinion is on that subject. And it doesn't work. I just had an argument with someone like that on Facebook. He doesn't understand that we're talking about passports. He's bringing the immigration in, the definitions for immigration. He's bringing in definitions from Title 42, which is the Social Security stuff and whatever else. Like, dude, you know we're being specific here, right? With Title 22 specifically dealing with passports, and you're throwing all these other definitions from other titles that are not included by reference. The definitions for United States are different for those titles and everything. Like, come on, man. When statute of limitation. Oh no, I didn't finish reading this right. Actions by or against states. Generally, states may invoke the statute of limitations in suits against themselves, but others may not invoke the statute of limitations in defending a suit brought by a state against them. Since a state cannot be sued without its consent, a statute of limitations does not begin to run in its favor until it has consented to be sued. Now, this right here, and I know people hate what I'm about to say, that doesn't mean that this is you or the state putting their signature on something. This is all based on what they're participating in too, their activities. Your activities show your intent. That's consent. You're doing the thing. And then have knowledge that you're doing the thing in their house or something. That's consent. You being born in one of the states of the Union, automatically making you a state citizen, that's consent. But it's not consent by the way you think that me saying, yes, me, I did that, or my signature. You gotta understand how this word consent is being used. Like the argument that, well, I didn't consent to the Constitution. And like, your fucking opinion matters. You were born in that state with that Constitution that was created by, supposedly we the people. A statute of limitations does not begin or run until it's in favor. It has consented to be sued. Thus, if an audit of an estate's assets revealed $10,000 in Pennsylvania highway bonds, which were in default over a considerable period, such period would not run in favor of the state unless it had consented to be sued. Criminal prosecution. Generally, time does not run against prosecutions for murder, kidnapping, or embezzlement of public monies. For other felonies, the period varies from 3 to 5 years. So they're talking about public monies. For misdemeanors, it is generally 1 or 2 years from the time the act was committed. When statute of limitations starts to run, the period of statute of limitations starts to run when a cause of action accrues. That is, when one's right to sue begins. This in a debt action is the date when the debt is due and unpaid. This in a debt action is the date when the debt is due and unpaid. So like for the example with the bond that they just said, it's when it was due at the end. So after like 10 years, 30 years or whatever. In an action of contract, when the breach occurs, in an action of contract when the breach occurs. So that's one. In a fraud action when the fraud was or should have been discovered. In a tort action when the tort is committed. And this is rough right here. This fraud one. When the fraud was or should. Well, then again, it says fraud was discovered. So like say the fraud happened 10 years ago, but you discovered it now. Would that work as the timer? Because this right here could be big. Like you being an accountant or something. You should have discovered it. You know what I'm saying? If you are a competent accountant. There's only like 2 more pages. Promissory notes. In an action of an ordinary promissory note, due at some point, some future time, the statute starts to run not from the date of the note, but from the date of its maturity. Demand notes. A demand note is due forthwith. The statute of limitations begins to run from the date of the note. This is the pervading rule throughout the country. 10 Corpus Juris Secundum, page 744. I might have to look that up. The reason why is because of what a demand note is. Okay, like banking, to understand what banking is. We know in common terms, banking is loaning out money, depositing money, borrowing money, whatever, right? Credit, all that shit. It comprises of a bunch of stuff, even being a depository, right? So that whole field, right? That should probably be the right term. The whole field of banking for the common person encompasses all these things. But in the Constitution, it does not. The only power of banking that we the people gave to the federal government, to Congress, over the power of banking is the creation of demand notes for the purpose of circulating as currency. That is what banking is under federal law. When it all comes down to it, that is what it is. Regardless of all the derivatives and all the other things that they could do with that, right? That to create banknotes and all that, that's what banking is. Not for us, but for them. This is why you being able to borrow money from private individuals, that's not illegal to do. Because those things are part of the field of banking, but that's not what a power that we gave to the government as a delegated power. We only gave them the power to create demand notes for the purposes of circulating as currency. Open accounts. An open account within the meaning of the various statutes of limitations is one in which some term of the contract is not settled by the parties, or where there are current dealings between them, and the account is kept open because of some contemplated future dealings, whether the account consists of one or many items. The account must be mutual, open, and current between the parties in order that it may fall within the purview of the statute, and transactions treated by the parties as distinct from each other and do not constitute an open running account. In an action brought to recover a balance due upon an open account, the statute starts to run from the date of the last item in the account at the point where the continuity of the account has been broken, and the final balance may be said to be due. What constitutes break in continuity of account? A demand for payment constitutes a break in the continuity of an account current. In an action to recover a balance due upon a mutual open and current account, reciprocal demands between the parties for payment of the balances allegedly due are necessary to constitute a break in the continuity of such account, upon discontinuance of the usual transactions of business. Only then is the account so closed as to start the statute of limitations running. When this happens, the last item in the account draws to itself all prior items, and these will be barred only when the statute has run against the last item. A demand may take any form showing an intent to discontinue the account unless payment is forthcoming. For example, an oral demand, if properly proved, would be sufficient. So, of course, would a written demand. The commencing of a lawsuit would constitute such a demand. A statement showing the amount due, followed by refusal to extend credit until the balance is paid, would likewise be the equivalent of such demand. Suspending the statute of limitations. Factors which suspend the statutory period are A. Disability of the plaintiff to sue, such as infancy or insanity, and B. Absence of the defendant from the jurisdiction so that he is not amendable to process. Absence of the defendant from the jurisdiction so that he is not amendable to process. In the former case, it would be unjust to count time against one unable to sue, and in the latter, to wipe out a debt in favor of one who placed himself in a position where he cannot be sued. So that's like an equitable principle. Like, why would you deny this person because of a defect, right? Their infancy or insanity, right? Or and this person, why would you screw over someone that's being owed money because the other fuck was able to go somewhere where we can't catch him? So the limitations is frozen. Statute of limitations is frozen. Claims by or against decedent estate. The filing of a claim with an executor or administrator suspends the running of the statute until the claim is finally determined in the surrogates or probate's court. Example, a claim for medical services was filed in the with a New York executor. The executor rejected the claim. 7 years later, the claimant sought payment by filing a petition for compulsory accounting. The executor contended that the claim was outlawed by the 6-year statute of limitations, but the court sustained the validity of the petition. The filing of the claim had suspended the statute. The original claim, the first claim, the claim for medical services. I wonder if the executor would have been able to do something to start the clock again. Like what would that take? But that's, of course, having knowledge that the statute of limitations for any claims against the executor, he knew that it stopped when this claim was filed. At least stopped for this person that made the claim or that action. Tolling the statute of limitations. To toll the statute of limitations is to start it running all over again, though the entire period of some part of it has already run. Factors which will toll the statutes are a written acknowledgement of the debt, from which the inference of a new promise to pay may be drawn. This revives the statute for the full period, starting with the date of acknowledgement. But such acknowledgement must contain nothing inconsistent with the debtor's intentions to pay. And I swear, because there's no money in the system, this is what you're supposed to do with a bank for like a mortgage and stuff, so you don't lose your house. You know, you write them, you're acknowledging the debt for whatever purpose, right? And of course, the goal is to discharge it. But this acknowledgement restarts any period for them to try to foreclose on you, to do anything. Because you're still saying, hey, man, I'm still paying you. I'm still doing this promise to pay. I just can't do the $1,500 a month or $2,000 a month no more. I got to cut it down to $1,200 or whatever it is. But that's assuming you're discharging your debt with Federal Reserve notes. But even then, if you're capable of discharging it with another note, right? That's different too. You know what I'm saying? I'm guarantee you that's possible. Because if you could do it with a Federal Reserve note, you could do it with your own promissory note. But your promissory note has to be backed by something. Federal Reserve notes are backed by something, just not an asset. They're backed by your labor and taxes, not a specific asset like gold and silver. When you do it, you can't do that. Well, I don't want to say that. But I know for sure you could do it write up a note with collateral on it back behind it. That now if you fail to pay the debt, then that collateral, you could lose the collateral. But nonetheless, you restarted the statute of limitations. Did the goal happen, right? You restart the statute of limitations. They can't foreclose on you. They can't do this. If you fuck up on the second attempt or negotiation to pay, right, then that's on you and your collateral that you're going to lose. The goal is don't fuck up. Do whatever you need to do properly to discharge the debt, whether that's with notes or another instrument. Federal Reserve notes, I meant, or with another instrument. This revises the statute of the fair period of the statute, but the acknowledgement must contain nothing inconsistent, right, with the debtor's intention to pay. If it is accompanied by a refusal to pay or by the contention, the claim is outlawed, so you can't collect. Or a declaration of unwillingness or inability to pay, or an offer to compromise will not toll the statute. Well, right here, they're saying a declaration of unwillingness. Well, really, an inability to pay. At least not inability to pay the amount that you were paying. So what's the difference between up here? Inference of a new promise to pay may be drawn. This revises the statute to full. I don't know what the difference would be. Right? This first sentence to here where but I guess here is you're stating your inability to pay. You don't include none of that shit, I guess. Just offer him a new promissory note. Offer him a new note. A new written acknowledgement of the debt. But don't state nothing about how you can't pay or whatever else. The effect of a written acknowledgement in reviving the debt is not dependent on the presence or absence of consideration. Payment on account, either of principal or interest from which a promise to pay the debt may be implied. Thus, payment of interest by the maker of a promissory note tolls the statute anew against the maker, but not against the endorser, unless he has authorized or consented to such payment. Claims not barred by statute of limitations. Certain claims are not subject to the statute of limitations, including, among others, an action brought by the federal government or by a state, except where the government specifically prescribes a time limit. See page 46. Oh, that's that 40-year period. Enforcement of an existing property right or lien. For example, if I own a diamond ring, your possession of it for more than 6 years will not defeat my title. Or if I pledged it with you more than 6 years ago, you would still have the right to foreclose. Let me read that again. Enforcement of an existing property right or lien. For example, if I own a diamond ring, your possession of it for more than 6 years will not defeat my title. Or if I pledged it with you more than 6 years ago, you will still have the right to foreclose to get your stuff back. Federal income tax delinquencies where a false or fraudulent return or no return at all is filed. That means they always have the ability to come after you. Prosecutions for murder, kidnapping, or embezzlement of public monies. Laches. Where a person delays in bringing suit, but the delay does not equal the period of statute of limitations, a court of equity may yet hold that the claimant was guilty of unreasonable delay in pursuing his remedy, and may thus bar the claimant by reason of such delay or laches. To plead laches, one must show that he has suffered some prejudice by the delay. Estoppel. There are many cases where one wronged is not guilty of delay in seeking redress, yet is barred or estopped from bringing suit by reason of previous conduct. Estoppel thus operates as a bar to prevent a person from taking a position inconsistent with one he has previously taken, where such inconsistency will work an injustice to an innocent person who relied on the position previously taken. 3 kinds of estoppel are: 1. Equitable estoppel, estoppel by judicial record, and that was number 2. And number 3, estoppel by deed. Estoppel en país, I would say país for Spanish, so estoppel en país is one raised against a person who, having taken a given position or assertion, denial, or failure to speak when there was a duty to speak, will not be allowed to reverse his position in such a way as to injure a person who relied on the position previously taken. Examples are agency by estoppel, partnership by estoppel, and corporation by estoppel. Estoppel by judicial record exists when a person sues on one theory on which a judgment is entered and later seeks to proceed on another theory contrary to the judgment. There's a court case that they did that. He's like, the judge telling him, how are we going to do this now that you changed your mind? And it was based on some tax stuff too. That you changed your mind on how the events unfolded or something like that. I forgot the whole thing, but man, I got it on my phone. I just don't know which specific case without looking. A judicial record imports absolute verity, and all parties thereto are estopped from denying its truth. Meaning what you said earlier, outside of provable whatever facts to the contrary that you lied or misled or something, those are facts. For example, after a judgment is rendered, the facts established thereby may not be denied by any party to the action except by way of appeal. Other examples: admissions by a party in court, agreed facts upon the basis of which a trial is had, stipulations of counsel, affidavits made by a party into a judicial proceeding, which the affidavit or party making the affidavit is not later allowed to deny. Number 3, estoppel by deed exists where a person recites certain facts, assurances, or covenants in a deed, which he later seeks to dispute. Example: I sell you a house, which I do not own. I give you a full covenant and warranty deed, in which I warrant, among other things, that I have title. You take possession. Later I obtain actual title from the true owner, who gives me a deed so that I become the true owner. I then seek to eject you on the ground that I am now the true owner and you are not. My ejectment proceedings would fail. I would be estopped by my prior deed from now disputing that I formerly warranted, namely, that when I sold you the property, I was the true owner. A person who invokes the doctrine of estoppel must show that he has been misled by the prior representation and that he will be damaged if the person who made it is permitted to reverse himself. And here, this end of it is questions and problems for review. What is municipal law? Define common law. Distinguish between jurisdiction of the court of law and the court of equity. And these are things that you should know. I swear, these are things that you go copy and paste this and ask ChatGPT if you don't want to find it in the book. Get some understanding and answers for these questions. Is a corporation a citizen? To answer your question, to B applies. So what's the question? A, number 10. How, in general, would you draw the line between interstate business and intrastate business? You know how important this question is? Because it's what I'm doing. How I'm avoiding interstate business to be taxed at a federal level. Are citizens of each state entitled to the privileges and immunities of citizens of the several states? State the authority for your answer, of course, which this is the Constitution, Article 4. Is a corporation a citizen to your answer in B? The answer is no. A corporation is not a citizen as in one of the citizens of the several states. Only people could be that. And that applies also to the 14th Amendment. Corporations cannot be citizens under the citizenship clause of the 14th Amendment. And no, I am not talking about the due process clause, because those are persons. I'm talking about citizens. Can a corporation be a citizen under the citizenship clause? And there are overwhelmingly a shit ton of court cases that say no. Only belongs to living, breathing people. But is a corporation a person? Absolutely. Did they make statutes for that? Were they call those corporations U.S. citizens? Absolutely. But those statutes have nothing to do with the citizenship clause and have everything to do with the due process clause and under the context of that a corporation is a person. Shit, these questions are general because this topic was not here in this book. I leave that to you guys. And I got this last little bit. I wonder why they did that. Questions before it's even done. They still got a little bit left. 21. Oh no, that's questions for never mind. That is done. Explain what is meant by the doctrine of estoppel. Name the 3 kinds of estoppel. You know, these things right here, they just said them. To really learn and this book, man, you got to answer some of these questions. Don't just listen to me. Actually, just go look, and I swear, ask ChatGPT. Ask something. Under what power is given to it by the Constitution of the United States did Congress enact the following legislation? Securities Act of 1933, Corporate Bankruptcy Act, Securities Exchange Act of 1934. I don't even know. It's executive. No, can't be. It's Congress. Under what power did they create the Securities Act? I don't know. And they got the simple one. Describe briefly the purpose of each of these acts. I don't know, but we're good. So the next one will be contracts. Right? Chapter 2, contracts, right? And how long is this chapter? I wouldn't even know. Haven't really looked. Still this chapter. It's going to be a few videos for sure. I try to do like 20 pages at a time. If I was just reading that, I was just reading, but I have my own little commentary, so the videos get a little bit longer. Like this chapter's long. Matter of fact, I might as well just go up here. Yeah, so pages 55 to 118. So you're talking about 60 pages, at least 65 pages, give or take. So look at 3 videos, maybe even 4. All depends. So with that, I'll end, and I'll see you guys next time. And ask questions. You know where you find me. Ask questions. And have a good one. And of course, like and subscribe to the Butterfly Monkey Effect channel. And ask me about any classes. Trust law classes, foreign estate, foreign interest, foreign trust classes too. Plenty of books, plenty of things to read. I got a lot of everything. Let me know.